Hi everyone, I'm Dan Caves and I am an annoyed law student. Why am I annoyed? Well, in evidence today, we had to read a case written by possibly my least favorite legal writer, Benjamin Cardozo. Now that name means pretty much nothing to anyone who hasn't gone through law school. Benjamin Cardozo is a brilliant historical jurist. He worked his way up in the early 20th century through the court system. He was the chief judge of the New York Court of Appeals, the highest court in New York State. He eventually elevated to the Supreme Court of the United States. Some of his opinions are among the most prominent and seminal case opinions in legal history. I can think of a few off the top of my head, like Paul's Graph versus Long Island Railroad is a famous torts case. Lucy versus Lady Duff Gordon is a famous contracts case. There's another contracts case I can't think the name of, but I can remember the facts. It's about like if you have someone build you a house and you specifically ask for a certain kind of pipe and they don't put in that kind of pipe, do you have a cause of action for that? That's beside the point. Brilliant man. Sure, he was a nice guy, but I find, for my taste, his writing is a little full of itself, a little too fancy. Maybe it's just modern training in legal writing. You're kind of steered away from writing like he did. I'm convinced that he had a novel in him that he just took out on law students for decades to come by writing these poetic, I guess is the nice way to put it, opinions. And today for evidence, we had to read one that triggered me like I didn't expect. And so I figured as a way of maybe like therapy, first of all, and second, to convey just how annoying I find it, it lends itself to what I'm about to do. I figured to illustrate my problem with Benjamin Cardozo's writing is to do a dramatic reading of the case that we read today in evidence. Now, to background this a little bit, this is a case about a hearsay exception. Hearsay, I'm not qualified to explain it really in any sufficient detail to, not sound like an idiot, but hearsay is an out-of-court statement made by someone, and at a future proceeding, it is offered to prove the truth of what was in the statement. So if you said out of court that John just killed Frank, and you try to offer it to prove that John killed Frank, that could be hearsay unless you find an exception to it. Then it comes in because it's probably reliable. This is about one specific hearsay exception. I'm not going to go any further than that. I think it's going to come clear through the case. Same thing with the facts. I'm not going to give you any setup beyond. Shepard versus United States. Volume 290, United States Reports, starting on page 96. Decided 1933. Mr. Justice Cardozo delivered the opinion of the court. The petitioner, Charles A. Shepard, a major in the Medical Corps of the United States Army, has been convicted for the murder of his wife, Zenana Shepard, at Fort Riley, Kansas, a United States military reservation. The crime is charged to have been committed by poisoning the victim with bichloride of mercury. The defendant was in love with another woman and wished to make her his wife. There is circumstantial evidence to sustain a finding by the jury that to win himself his freedom, he turned to poison and murder. Even so, guilt was contested and conflicting inferences are possible. The defendant asks us to hold that by the acceptance of incompetent evidence, the scales were weighted to his prejudice, and in the end, to his undoing. The evidence complained of was offered by the government in rebuttal when the trial was nearly over. On May 22nd, 1929, there was a conversation in the absence of the defendant between Mrs. Shepard, then ill in bed, and Clara Brown, her nurse. The patient asked the nurse to go to the closet in the defendant's room and bring a bottle of whiskey that would be found upon a shelf. When the bottle was produced, she said that this was the liquor that she had taken just before collapsing. She asked whether enough was left to make a test for the presence of poison, insisting that the smell and taste were strange. And then she added the words, "Dr. Shepard has poisoned me." She said, "Dr. Shepard has poisoned me." The admission of this declaration, if erroneous, was more than unsubstantial error. As to that, the parties are agreed. The voice of the dead wife was heard in accusation of her husband, and the accusation was accepted as evidence of guilt. But if the evidence was incompetent, the verdict may not stand. Witnesses for the defendant had testified to declarations by Mrs. Shepard, which suggested a mind bent upon suicide, or at any rate were thought by the defendant to carry that suggestion. More than once before her illness, she had stated in the hearing of these witnesses that she had no wish to live and had nothing to live for, and on one occasion she added that she expected someday to make an end to her life. This testimony opened the door, so it is argued, to declarations in rebuttal that she had been poisoned by her husband. They were admissible in that view, not as evidence of the truth of what was said, but as betokening a state of mind inconsistent with the presence of suicidal intent. The defendant had tried to show by Mrs. Shepard's declarations to her friends that she had exhibited a weariness of life and a readiness to end it. The testimony given plausibility to the hypothesis of suicide. By the proof of these declarations evincing an unhappy state of mind, the defendant opened the door to the offer by the government of declarations evincing a different state of mind, declarations consistent with the persistence of a will to live. The defendant would have no grievance if the testimony and rebuttal had been narrowed to that point. What the government put in evidence, however, was something very different. It did not use the declarations by Mrs. Shepard to prove her present thoughts and feelings, or even her thoughts and feelings in time past. It used the declarations as proof of an act committed by someone else as evidence that she was dying of poison given by her husband. This fact, if fact it was, the government was free to prove, but not by hearsay declarations. It will not do to say that the jury might accept the declarations for any light that they cast upon the evidence, the existence of a vital urge, and reject them to the extent that they charged the death to someone else. Discrimination so subtle is a feat beyond the compass of ordinary minds. The reverberating clang of those accusatory words would drown all weaker sounds. It is for ordinary minds, not for psychoanalysts, that our rules of evidence are framed. They have their source very often in considerations of administrative convenience, of practical expediency, and not in rules of logic. When the risk of confusion is so great as to upset the balance of advantage, the evidence goes out. These precepts of caution are a guide to judgment here. There are times when a state of mind, if relevant, may be proved by contemporaneous declarations of feeling or intent. Thus, in proceedings for the probate of a will, where the issue is undue influence, the declarations of a testator are competent to prove his feelings for his relatives, but are incompetent as evidence of his conduct or of theirs. In suits for the alienation of affections, letters passing between the spouses are admissible in aid of a like purpose. In damage suits for personal injuries, declarations by the patient to bystanders or physicians are evidence of sufferings or symptoms, but are not received to prove the acts, the external circumstances through which the injuries came about. Even statements of past sufferings or symptoms are generally excluded, though an exception is at times allowed when they are made to a physician. So also in suits upon insurance policies, declarations by an insured that he intends to go upon a journey with another may be evidence of a state of mind lending probability to the conclusion that the purpose was fulfilled. The ruling in that case marks the high water line, beyond which courts have been unwilling to go. It has developed a substantial body of criticism and commentary. Declarations of intention, casting light upon the future, have been sharply distinguished from declarations of memory pointing backwards to the past. There would be an end, or nearly that, to the rule against hearsay if the distinction were ignored. The testimony now questioned faced backward, not forward. This, at least, it did in its most obvious implications. What is even more important, it spoke to a past act, and more than that, to an act by someone not the speaker. Other tendency, if it had any, is a filament too fine to be disentangled by a jury. Wow. I feel a little flustered even reading that out to you. I'm not sure if I conveyed properly the annoyance that I have with this kind of writing. First of all, I mean, like his opinion of jurors, very low, maybe well deserved, but he's not hiding it at all. So it's a little highfalutin, and it's a little elitist in its tone, and I just think it's a little over the top. That's really my gripe with it. We're expected as new 21st century law students to write as clearly and as straightforwardly as possible. And yes, there can be beautiful language in some judicial opinions. I think that there are still great writers out there. But it's definitely a sign of its times. It is a product of the era where it came from. But even older cases, they're not this thick. They don't lay it on this thick. So that is Shepard versus United States by the great and powerful Benjamin Cardozo, who, once again, utmost respect for his thinking and his logic, but I think his writing is just not my bag. So thanks, guys. Bye. Back to the quarantine.